Welcome to this lecture on sources of international law. In this lecture, we will look at different sources of international law and what are their important roles in the formation of international law. So, we have five different kinds of sources which we will study one by one. So, moving on, first with a brief introduction of about the topic of sources of international law. So, what we need to understand is that there is no single body which can create international laws, okay? Because there is no system of courts, there is no comprehensive and compulsory jurisdiction to interpret the extent of law. So, as there is no institution and there is no system of courts, we are facing problems when it comes to defining the sources of international law. Now, this perplexity or this confusion or this problem is reinforced because of the anarchic nature of world affairs, and there is a clash between the sovereignty of one country and another country. Okay, so there is a clash of competing sovereignties. What does this mean? This means that the sovereignty of India or Indian state says that international law should follow these principles. The United States believe that international law should follow these principles. So there is a clash of sovereignty, okay, when it comes to international law. Now there are sources available from which we can extract the rules and analyze them. Okay. Now, what do we really mean by the term sources? Okay, this needs to be understood when we are saying sources. Now, what do we really infer from the word sources? We mean provisions operating within legal system on technical level. So, when we want to understand what are sources of international law, what we really look is that the provisions through which our international legal system is working. Okay, so we are looking at these these provisions and not at any other level but at technical level. So we are going into the technicalities of this. Now, the most important source of international law is Article 38, subclause 1 of International Court of Justice. Okay, it is the most authoritative and complete description of sources of international law. Okay, it is widely recognized as the most authoritative and complete statement when we are discussing the sources of international law. So we will try to read this article. Okay, it is the article 38.1. This is a very important article from your examination point of view. So article 38.1 of the ICJ. Now it talks about the different sources. Let us read these sources. So the court whose function is to decide in accordance with international law, such disputes are submitted to it shall apply. Okay, so the court will apply, the International Court of Justice. Okay, the court will apply these principles. Okay, the court will apply these principles. And what are these principles? The first principle is international conventions. Okay, whether they are general or particular, or establishing rules expressly recognized by the contesting states. Okay, this is the first subclause. So these are nothing but our customs. These are nothing but the treaties. Okay, So these are the conventions, are the treaties, so that different countries enter into different treaties. So treaties are the first source of international law on the basis of Article 38 clause 1 of ICJ. Then the second source is the international custom. It is described as the evidence of general practice. So there is a evidence. The customs are treated as a source of law, international customs, as they are the evidence, and it is also accepted by law. Third source based on this definition is the general principles of law recognized by civilized nations. So what does this mean? That there are certain principles which the entire world, or which the civilized nations have accepted. They recognize these principles. So these principles are also a source of law. We will discuss each of these sources one by one in complete depth. Okay, the depth which you will get will suit you for almost every examination which deals with international law. Okay, then comes the fourth source, which is subject to the provisions of Article 59. Okay, Article 59, the judicial decisions, these are another source. So another source is judicial decisions and teachings of most highly qualified publicists of various nations. So the writings of the jurist. Okay, so here the definition is talking about writings of jurists. Okay, so this is the definition. This is the fourth is the judicial decisions, and fifth is the writing of the jurist. Okay, these are the sources of law. Further, in the second subclause, we have said that these provisions, or these are not the only sources. Okay, the court can decide the cases on the basis of ex equito et bono. Okay, on the basis of good faith, and if the parties are agreeing to. Okay, so these are the different sources of international law, keeping in mind the Article 38 clause 1 of International Court of Justice. Okay, now what the writers have done. Okay, let us move further. Now the different jurists have done that they have tried to create a distinction. Okay, a distinction in these resources. So first let me summarize or write these resources, then you will be able to understand them on a much